Good afternoon, everybody. My name is Dalibor Vojta. I'm a lawyer from the unit R5 at DG Connect, Program Operation, and I'll give you a short presentation on amendments in the CIP projects. My presentation will have the following content. First, we'll discuss what it is an amendment, when a grant agreement needs to be amended, how to amend a grant agreement, how to implement it, what is the difference between entry into force and taking effect. We will mention also some changes that don't require an amendment, and then at the end I'll give you some examples of maybe the amendments that you will encounter most often. So what is an amendment? Now you have your grant agreement signed. However, it may happen that during the lifetime of the project there are some changes that are necessary, that are due either to the involvement in the project itself or in the life of your organization's change. So then the grant agreement needs to be changed. These changes need to be reflected in it. And then the amendment itself is the legal act that modifies the commitments originally accepted by the parties. It means the commitments within that are embodied within the grant agreement itself. Rules regarding the amendments can be found in Article 2.1 of the grant agreement in Annex 2. And of course, there are also guidelines provided by the Commission how to implement the amendment. I will mention them later with a link to it. Only written amendments are valid, so and binding upon both parties, so no changes accepted by phone calls or at meetings, all must be in written. The amendment itself then becomes, after it's implemented, becomes an integral part of the grant agreement, so either it replaces or complements the original provisions of the grant agreement. And also be aware that not all the parts of the grant agreement, not all the obligations may be amendment. For example, anything that is in Annex 2 is out of the question. This annex cannot be modified. Basically, what you will usually be able to modify, what the Commission cannot accept to modify, is anything that was negotiated during the negotiation of the grant agreement itself. So the things that could be changed in the core grant agreement itself, and of course Annex 1. So when to amend the grant agreement? As a general rule, an amendment request is necessary whenever the grant agreement has to be modified. It means whenever there is any change in the data that are included in the core part of the grant agreement or in the Annex 1, or also in the case you want to proceed in the project in a slightly different way than it's previewed in your Annex 1 again, you must request an amendment to be allowed to do so, to have your cost eligible, for example, for new tasks. However, the modification of the Annex 1 cannot and must not have the purpose of making change that might call into question the selection of your project, the decision awarding the grant, or result in an unequal treatment of participants in the call. So it means, for example, if your grant agreement was selected based on some specific tasks that were previewed, and that's why you received high markings from the experts, and then that's why you were selected in comparison with, in competition with the other proposals, and then during the first year of the project you suddenly submit a request for amendment saying, well, we will not be able to fulfill those tasks. We'd like to amend the grant agreement and just get rid of those tasks. Then of course the Commission will not accept such a request, and either you will be able to complete your project as previewed in your original proposal, or we will terminate the grant agreement itself and not fund it anymore. Some changes, however, in the grant agreement doesn't need to have this rather, maybe not heavy, but a complicated procedure, and they can be implemented via a little less formal procedure, so-called information procedure. I will speak about it later. And also, before introducing the request for amendment, we strongly recommend you to, or suggest you to contact your project officer and discuss the content of the amendment with him a little bit So he's aware, maybe he can give you some informal feedback, especially if it's about the modification in Annex 1. You can discuss what is acceptable for him, what not. So when you submit officially the request, it will be already, let's say, the package that was informally agreed before, at least with the project officer, and you will not get into the position that the request will be rejected, and you will have to maybe restart again. So how to implement an amendment? Basically, an amendment of a grant agreement is exchange of letters. So it's a request for amendment. That's usually a letter sent by US coordinators. And this letter, then, if the amendment is accepted, should be mirrored in so-called acceptance letter or from the Commission that says basically that the Commission agrees with whatever you propose. Please be aware that these two letters must match each other perfectly. It's not possible that the Commission, you will send a request and then the Commission will say, well, we like it partially, but we accept it with some modifications. No, we cannot do that. We have to either accept it or not. There is one, I would say, exception, but a tricky thing that very often you will combine several modifications in one request. For example, you will need to have a new beneficiary. You would like to have a new beneficiary, so of course there will be addition of a new beneficiary. There will be necessary modification of Annex 1 because you have to add a new task to the beneficiary. And maybe you will also would like to change a bank account of you as a coordinator because your organization changed a bank account. So if you don't say anything, we have to take this request as one package, and maybe we will not agree with the addition of a new beneficiary, but of course we wouldn't have nothing against modification of your bank account. However, we would have to reject or refuse the request as it is because it will be in one package. However, you can avoid that because you can include a sentence that will say basically that all the requests for amendment can refers to several clauses, and those can be treated separately. So in such a case, we would maybe reject the addition of a new beneficiary, the modification of Annex 1. Well, we will accept the modification of your bank account. This specific sentence is written in one of the templates we have in the guidelines for amendments you can download on the participant portal. I strongly suggest you do before, if you want to submit a request for amendment, I strongly suggest you read those guidelines, and I suggest you use the templates. We will not reject your request only because it does not use the template that is in the guidelines, but from experience we know if you use the guidelines there is a higher probability that your request will be complete, correct, with all necessary documents. So that's why we suggest it. And the amendment request must be signed by the person who has the same authority in your organization as the person who signed the grant agreement itself. It does not necessarily have to be the same person. This person might have changed, or there might be several persons with the same power in your organization, but that must be somebody who has legally the authority to bind your organization and modify the grant agreement. So we started with the request from US coordinator. You submit, US coordinators, you submit the request on behalf of the consortium. However, there is one specific case when this does not happen, and it's when the coordinator is replaced by the consortium against his own will. So the coordinator still wants to be the coordinator, but the rest of the beneficiaries don't want to. So they have the right to ask the Commission to replace him. But if this is the case, If this is the case, then that must be all the beneficiaries who signs the grant agreement, who signs the request for amendment, or one of them representing the rest of them. You don't have to ask all the beneficiaries to sign the grant, to sign the request for amendment, but you must have, in case of an audit, proof. You must be able to prove that all other beneficiaries, all the consortium agreed to it. We don't know your consortium agreement, so there might be some parts of the grant agreement that might be modified. Maybe, I don't know, to the two-third majority of beneficiaries or something that we don't know, but you must have the proof that the consortium agree because you submit it on behalf of the consortium. And for your call, there's no tacit approval of the amendment. So if you don't receive anything from us, it means we don't agree. Not that we agree, no tacit approval. However, you will always receive something from us, and it always should be, even though the grant agreement doesn't set us any deadline, we do it within 45 days. If you did not receive any reply from the Commission within 45 days after you submitted your request, please contact the Commission again, ask whether it arrived. We didn't confirm, because normally you should receive our acceptance or rejection within 45 days. How the request must look like. So first, must be complete. It means it must contain all the necessary documents, supporting documents that you must submit together. You will see all the list of the documents for each particular amendment in these guidelines, and I will later mention some of them when I will give some examples of amendments. Must be unambiguous, so it must refer to the, must be clear to which grant agreement it refers to, what should be amended, and also it means that happens sometimes that really you submit the request and it must be in agreement with the content of the supporting documents you submit. For example, happens sometimes that we receive requests for amendment, again for addition of new beneficiary. In the request itself you write that you want to have the new beneficiary from 1st September. And as one of the supporting documents, you must also submit so-called Form B, which is some kind of accession form of this new beneficiary. And there's also the date, and the date will be 1st of December of the same year. And then for us, this is unclear. We cannot accept it because we don't really know which is the correct date you want. Yeah? So be aware that not only that you must be clear in your request, but the request must match also all the attachments and supporting documents you submit. Of course, must be submitted in writing. We already spoke about it. And it must be submitted in time, so immediately after the event occurred and not months later, which sometimes happen. However, we are aware that it's also, sometimes it's not the fault of the coordinator. He might not be aware of certain facts that beneficiaries did not communicate to him. But yeah, once you know that there's something that needs, that maybe may require the amendment, please contact the Commission and submit the request for amendment if necessary. In time also means during the lifetime of the grant agreement. So basically an amendment can be done between the starting date of the project and the final payment, with also the request itself that should be submitted during the lifetime of the project. However, there are of course some exceptions to these rules. Again, we can to the bank account if the project is already over, but there's still, the final payment is still in preparation. Your organization changed your bank account. You submit a request, of course we will accept it because we want to send the money to the correct one. And what is the difference between entry into force and taking effect? Amendment itself enters into force upon the date of signature by the second of the party, usually it's the Commission. You submit a request. When we receive it, we approve it, the director signs it, then that's the entry into force of the amendment. However, some clauses might have take effect at a different date. Again, if we take the example of addition of a new beneficiary, you know you will need a new beneficiary at the beginning of 2014. You submit your request somewhere in September 2013. In October 2013, the request is signed, but in the amendment itself would be that the new beneficiary, the addition of a new beneficiary takes effect on the 1st of January 2014. Yeah, so that is the difference. Now there are many changes that occurs also that don't require an amendment. Mostly these are changes that are either not so important or that relates to beneficiaries themselves directly, and there is actually nothing that the Commission can or has to approve. That's something that happened in the life of the company, or of the university, of the institute, and we just need to know about it. But we don't give any approval to it, or we can't. These changes is usually change of legal name, address, etc. These changes must be introduced via LIR on the level of the beneficiary, of the entity, not even of the project, because the beneficiary may be involved maybe in several projects, 15 or more. And we will register this change only once, and then we will send you a request, a letter, so-called information letter, that will basically tell that we acknowledge these changes that were undergone by one of the beneficiaries, and we changed it in our databases. We don't require any action on your side, unless there is some changes that you are aware of, and you are obliged to, based on the grant agreement, to inform us. Maybe we don't know, so you inform us, and then again, either we go back to the beneficiary that he should submit some request via his LIR, or we will just acknowledge the receipt and change the information in our databases. Yes?
Does the PIC remain the same?
I mean, if you change your name, legal name, or if you change legal address, yes, the PIC is the same.
Sorry, we have one of our partners has changed legally his name, and he basically did the whole procedure of getting a new PIC number. At that point, there's an amendment to it that needs to be done, or can we just simply notify that there's been a transfer of company with the PIC number?
The microphone.
What you are speaking about seems more like a transfer of rights and obligation. That's a different story, and I will mention it a little bit later, so maybe it will become clearer. There are other changes that don't require an amendment, like contact address and legal representative of a beneficiary, names or contact details of person making and monitoring the work, any event that may affect the implementation of the project and rights of the union. If you see Article 2.3F in the grant agreement, that we have to be, or you have to notify the Commission about it as well. And there we will acknowledge the receipt, put it in our file, and have the information. So, and now we're coming to some cases of amendment procedure, or this so-called information procedure. Addition of a new beneficiary, we spoke about it, so request for amendment, there will be addition of a new beneficiary, and there will be always a modification of description of work, because you need to add some tasks to beneficiary, otherwise there's no point to have a new beneficiary. So we will always expect having at least these two clauses. So what you must add to this, what you must enclose with this request, of course, modified Annex 1 with the description of work of the new beneficiary, sign the GPFs of the new beneficiary, so the A25 form, and you will have to fill in all the data in F. Duly signed Form B. This is a form that's signed by both new beneficiary and the coordinator, so don't forget to have these two signatures, and again said, please be consistent with the accession, for example, the accession date, and also other data with the request. And also you might add an accompanying letter, cover letter, with the context of the addition of the new beneficiary, but maybe this is not a mandatory attachment, because maybe that will be already clear to your project officer because you had lengthy discussion over email why you want the new beneficiary, why he's added, so he maybe know. But it's always better to add at least few words with the amendment itself, even if you know that the person on the other side will know it, because that's possible that the person on the other side will change during the lifetime of the project, and then it would be nice for the new one who takes over to know the context of the changes of the grant agreement. The new beneficiary must be already registered, so must have its own PIC, and in some specific cases, in pilot A, for selection of the new beneficiaries, if you have this clause selected, a competitive call might be requested, and for thematic networks with lump sum, new beneficiaries cannot be funded. The next possible amendment is a termination of the participation of the beneficiary. Again, there will be in the request you must have this request for termination. Again, modification of the description of work, because there are some tasks probably of this beneficiary that is terminated that will not fulfill. So either you redistribute these tasks among the remaining beneficiaries, or you will add a new one who will take over these tasks. So as a supporting document, again, you must have a modified Annex 1 with this task, letter of opinion of the beneficiary whose participation is terminated. That will be easy if it's on his own request. He says, okay, my company policy changed, we don't do research anymore, we want out. That's easy. However, sometimes you will terminate maybe a beneficiary who just stopped communicating, you don't know what is going on, he doesn't deliver what he was supposed to do, so then he doesn't even deliver, he doesn't react. So, of course, we understand you can't really provide us with his opinion on this matter, but then we will request any proof that he was requested to express his view and the deadline expired, he didn't give you any, so we'll be fine with that as well. And again, this accompanying letter why you want to this change applies the same as I said before. Another example of modification of an amendment is change of coordinator. Different situations can happen. One is when the old coordinator agrees, for some reason he doesn't want to be coordinator anymore. Then the request should be normally signed by both the new and the old coordinator, because the consortium can never remain without a coordinator. We'll never accept a request for termination of a coordinator without having another one already. Or is a change of the coordinator without his agreement, I already mentioned it, that's then must be signed by all beneficiaries, so by one who represents all the others. If the new coordinator is not already beneficiary, you must also having the clause addition of a new beneficiary. It's not enough to just having, because coordinator, it's a role, so you need to add a beneficiary and give him the role of the coordinator. And then that's a question whether the old coordinator remains a part of the consortium. If he doesn't, also you must include the clause termination of a beneficiary. In all cases, because coordinator has many responsibilities within the consortium, and there are many more data relating to him in the core grant agreement than to other beneficiaries. So the request must contain modification of bank details for the new coordinator, communication of the new contact address that is in the core grant agreement, and of course modification of Annex 1. Again, you have to submit or enclose the supporting documents same as for addition of a new beneficiary, with an additional document that is the financial documents in case they are necessary for verification of the financial capacity of the new coordinator, and also in the GPFs not only the sign A25 and A26 form, but also the new form with the banking detail of the new coordinator. And now we're coming to a little tricky part that was already mentioned. It's transfer of rights and obligation. This is a clause or amendment or information letter that is used in cases such as mergers, acquisitions, that goes beyond only change of ownership. If it's mere change of ownership, so let's say one company buys the shares of another one, it's change of ownership, but within the company itself that was bought, it doesn't change anything. We want to be informed that it really that it happened, because it can trigger some further events, but it's not really a case for an amendment or information letter. But in case of acquisitions or mergers, that's a different story. This transfer can be universal or partial. If it's universal, it's a case of takeovers. The new entity basically assumes universally all rights and obligations of the old entity. Again, there is nothing we can do about this. It's something that happened in the lifetime of the company, and we just have to reflect it in the grant agreement. So there is no need for an amendment request. Only in cases the beneficiary is a coordinator or there are some special condition that needs to be inserted in the grant agreement because of the transfer. And we will basically, this will be done again usually by the leader of the company, and if that will be the case, the company might disappear and have a new PIC, because it was absorbed completely by another one, and the other one, the new one, will become a member of the consortium now. And if that will be the case, there will be a change of PIC, but again, it will not be an amendment, it will be information procedure, but the PIC will be changed. Or there might be a different story. If it's just a partial transfer of rights and obligation, then it will be necessary to have an amendment. What does it mean, partial transfer of rights and obligation? I have here basically examples that should enlighten it a bit. Let's say we have a company and there's an entity that purchases part of this entity, mobile phone division. And if the project, your project, involved this mobile phone division, they were working on it and they still will keep working on it, but already part of a new company, then an amendment will be necessary. However, if they don't buy the mobile phone division, but they buy another one, your division is not affected, the one that works on your project, that no amendment is needed. We don't. It's a business of the company. There's nothing to be done about it. Or there can be also a case when the original entity you have as a beneficiary splits in two, and there's no universal transfer of rights and obligation to either of them. Again, an amendment will be necessary. And again, there'll be a new PIC of this one of these new entities that will become a beneficiary in the grant agreement. So in short, amendments: legal act modifying the initial agreement, implemented via exchange of letters, always in writing, be careful it's signed by authorized persons, request must be complete, clear, submitted on time, only during the lifetime of the grant agreement, no tacit approval, and please read the amendment guidelines that are on the link on the presentation. And that would be all. Do you have any questions? Yes?
I have a question because probably one of the partners of the project which were involved made a mistake in the sense the only change was they changed their name, but it's fundamentally the same organization, actually is even a public organization, but they asked for a new PIC as if they were a new organization. So I think that the Commission now has two different partners, but actually the two partners are exactly the same with the two different names. What should we do? Because in reality, they should have asked for an outro and not for creating a new, or not even that. In reality, they had only to change through the layer the name of the organization.
Yeah, of course. It's must be, first, as I said, this is a change that's undergone on the legal entity level. So it does not affect only your project, and because if they have more, it's affecting all of them. And the change will be done once in our central database of legal entities, of beneficiaries, where they receive PIC. So the unit that is taking care of it must be informed about this problem that they registered wrongfully, and this specialized unit will, let's say, re-register them, and then we will let you know. But it must be.
So actually, we have to undo what they've done. We have to ask them not to use the new PIC, but simply to modify the name of the organization with the original PIC. Because that automatically will update all the projects in which they are involved.
Yes, they actually should, their layer should go to through the registration, to the registration unit, and explain the situation. They will probably ask him for supporting documents, and it will be changed, and then all the project will be informed, all the projects.
Yes, I have this question about the timing. So you said that an amendment can be implemented during the lifetime of the project, but should be introduced before the end. What do you mean by introduced?
That the request should be sent before the end of the project. Yeah. Okay.
Actually, I've listened to what you said before. Inform or submit a request for amendment as soon as you are aware of a change. But we tend to manage very large consortia, and let's say in a year we have 10 to maybe 12 different changes, and I think it would be really an enormous work for European Commission to have to amend every time the consortium. So what we have done until now, I hope that is not wrong, we try to bring together a number of changes before we ask for an amendment, just to reduce the amount of work, not for us, but also for the European Commission.
No, I perfectly understand that, and it's hard to tell not to do it, or on the other hand encourage you to do that, because that's really how you have to see on a case-by-case basis, because some changes that you undergo might have a substantial impact on the grant agreement. Maybe you may reconsider the whole grant agreement, so we need to know quite soon. There are some changes that have substantial impact on accepting costs, for example, addition of a new beneficiary. You say, well, okay, I have here a new beneficiary, he will start working on the project, or a new third party, or whatever, and then you submit the request for amendment only a month later, and he's already working. If he's not accepted as a new member of the consortium, no cost will be reimbursed. So you have to always see case-by-case basis. If it's just, I don't know, just a change of address, I understand you don't really have to run to explain to us, or if you know that your organization modified your bank account, okay, it's you should let us know before payments, but you don't really have to hurry and do it the second day it happened. But again, be careful, because the impact of not submitting a request might be severe in some cases.